Hello students, welcome to the lecture on indemnity and guarantee and bailment. After this lecture, you will be able to learn the following objectives. Describe the meaning of contract of indemnity and contract of guarantee. Describe the general principles of rights of indemnity holder. Describe in detail types of bailment. Explain the classifications of termination of bailment. Define the right of surety. Now let us know more about indemnity and bailment.
An indemnity is a sum paid by A to B by way of compensation for a particular loss suffered by B. The indemnitor may or may not be responsible for the loss suffered by the indemnity. Forms of indemnity include cash payments, repairs, replacement, and reinstatement.
General and legal meaning.
Indemnity is often used as a synonym for compensation or reparation. All three can be construed as obligations to act on an injured party's behalf given the occurrence of a contractually specified event. However, indemnity as a legal concept has a much broader meaning than the other two terms. Namely, an indemnity is to make a party to a contract whole again should that contractually specified event occur. While the event may be specified by the contract, the actions that must be taken to make the injured party whole again are largely fact-based and unknown to the parties until the event occurs, while the maximum liability is often expressly limited by the contract. A car insurance policy is an example of indemnification. If a purchaser of car insurance policy is involved in an accident wherein the liability for the accident is undisputedly of their insured driver, then the insurance carrier has the duty to indemnify their insured driver in very specific ways to make them whole again. The insurance carrier may pay them compensation recompense for lost wages that would have normally occurred, pay them for medical legal/pain and suffering damages, that is, those costs arising specifically as the result of the accident, reparations to tow and repair the vehicles involved in the accident returning them to their original condition, and the payment of rental vehicles while awaiting repairs. It is in the breadth of the insurance carrier's obligations that we see the application of an indemnity. In other words, an indemnity is a generalized promise of protection against a specific type of event by way of making the injured party whole again. An indemnity should also be differentiated from a guarantee. A guarantee is the promise of a third party to honor the obligation of a party to a contract should that party be unable or unwilling to do so. Usually a guarantee is limited to an obligation to pay a debt. This distinction between indemnity and guarantee was discussed as early as the 18th century in Berkmia v. Darnell. In that case, concerned with a guarantee of payment for goods rather than payment of rent, the presiding judge explained that a guarantee effectively says let him have the goods. If he does not pay you, I will.
The contract by which one party promises to save the other from the loss caused to him by the conduct of the promise himself or by the conduct of any other person is called a contract of indemnity. The person who promises to make good the loss is called the indemnifier promise, and the person whose loss is to be made good is called the indemnified or indemnity holder promises. The term bailment is derived from the French word Baler, which means to deliver a thing under a contract. The person who delivers the goods is known as the baler, and the person who receives the goods is known as the bailee, and the transaction is known as bailment. Essential elements of indemnity contract. Following are the essential elements of the indemnity contract. Loss to one party. A person can indemnify another person only if such other person incurs some loss or is about to incur some loss. Therefore, a contract of indemnity can be performed only when the loss has incurred to the promise or the loss to the promise has become certain. Indemnity by the promise. The purpose of the contract of indemnity is to protect the indemnity holder from any loss that may be caused to the indemnity holder in future. That is, such a loss has not already been caused to the indemnity holder. Reason for loss. The contract of indemnity may specify that the indemnity holder shall be protected from the loss caused due to the action of the promissory or the action of any other person or any act, event or accident which is not in the control of parties. Essentials of a valid bailment. The essential features of a valid bailment are as under. Delivery of possession. The delivery of goods may take place either by way of actual delivery or by constructive delivery. An actual delivery means the bailer hands over the physical possession of goods to the bailee. A constructive delivery means some act on part of the bailer which has the effect of putting the goods in the possession of the bailee. The bailment is not possible with immovable property. Contract between parties. There must be a contract between parties. The contract must provide for the transfer of the possession of goods from one person to another. The contract may be expressed or implied. Sometimes the bailment may arise even without the contract, that is, finder of goods is treated as a bailee. Delivery for some purpose. The delivery of goods must be for some purpose. The purpose could be the safe custody of the goods or the transportation of goods. The purpose may be expressly specified in the contract or may be implied from the circumstances. Return or disposal of goods. The goods must be delivered to the bailee for some purpose and subject to the condition that when the purpose is achieved, the goods shall be returned to the bailer or disposed of according to his direction. Types of bailment. A bailment can be classified on the basis of reward or on the basis of benefits. The bailment on the basis of reward can be classified as gratuitous bailment. It is a bailment of goods without any charges or reward. The bailee is not required to pay any charges for the bailment. Non-gratuitous bailment. It is a bailment for some charges or reward. The bailee is required to pay some charges to the bailer. The bailment on the basis of benefit may be classified in the following three manners. Bailment for the exclusive benefit of bailer. It is the bailment in which the goods are delivered by the bailer to the bailee only for the exclusive benefit of the bailer himself. Bailment for the exclusive benefit of bailee. It is the bailment in which the goods are delivered by the bailer to the bailee only for the exclusive benefit of the bailee. Bailment for mutual benefit of both bailer and bailee. It is a bailment in which the goods are delivered by the bailer to the bailee for the benefit of both the parties. Essential elements of indemnity contract. Following are the essential elements of the indemnity contract. Loss to one party. A person can indemnify another person only if such other person incurs some loss or is about to incur some loss. Therefore, a contract of indemnity can be performed only when the loss has incurred to the promise or the loss to the promise has become certain. Indemnity by the promise. The purpose of the contract of indemnity is to protect the indemnity holder from any loss that may be caused to the indemnity holder in future. That is, such a loss has not already been caused to the indemnity holder. Reason for loss. The contract of indemnity may specify that the indemnity holder shall be protected from the loss caused due to the action of the promissory or the action of any other person or any act, event or accident which is not in the control of parties. Indemnity contract. A contract of indemnity is a special contract. The contract by which one party promises to save the other from the loss caused to him by the conduct of the promise himself or by the conduct of any other person is called a contract of indemnity. The person who promises to make good the loss is called the indemnifier, promissory, and the person whose loss is to be made good is called the indemnified. Right of indemnity holder. The indemnity holder has the right to recover the following from the indemnifier by way of compensation. Right to recover damages. The indemnity holder is entitled to recover from the indemnifier all the damages which he is compelled to pay in any suit in respect of any matter covered by the contract of indemnity. Right to recover costs. The indemnity holder is entitled to recover from the indemnifier all the costs which he is compelled to pay in bringing or defending such suit. Right of indemnity holders. The indemnity holder has the right to recover the following from the indemnifier by way of compensation. Right to recover damages. The indemnity holder is entitled to recover from the indemnifier all the damages which is compelled to pay in any suit in respect of any matter covered by the contract of indemnity. Right to recover costs. The indemnity holder is entitled to recover from the indemnifier all the costs which he is compelled to pay in bringing or defending such suit. It may be noted that the indemnity holder must act within the scope of his authority, and while bringing or defending the suit, he must act as a prudent person. Right to recover sums paid in compromise. The indemnity holder is entitled to recover from the indemnifier all the amount which he has paid under the terms of a compromise of a suit. However, he must act within the scope of his authority. While in a compromise, he must act like a prudent man. Bailers and surety rights. The duties of the bailee are the rights of the bailer. In addition, the bailer has the following rights. Enforcement. The bailer has a right to force the bailee to perform his duties. The bailer can compel the bailee to take proper care of the goods. If the bailee neglects his duties, the bailer has the right to enforce by filing a suit to the court. Termination of bailment. If the bailee uses the goods in an unauthorized manner, the bailer can terminate the bailment before the completion of the bailment. A contract of bailment is regarded as a voidable contract. In such an event, the bailee cannot suit the bailer for a breach of contract. File suit against wrongdoer. To protect his goods, the bailer has a right to take a legal action against any person who has caused any loss or damage to the goods. Demand goods at any time. In gratuitous bailment, the bailer has a right to demand the return of goods even before time. The surety has certain rights against the creditors, the principal debtor, and the co-sureties. Right of subrogation. A subrogation means substitution of one person for another. According to this right, when the surety has paid the debt or discharged the performance of the debtor to the creditor, he is vested with all the rights which the creditor had against the principal debtor. Right of indemnify. The surety is entitled to recover from the principal debtor whatever sums he has rightfully paid. The amount includes loan, interest, and other costs, if any, paid to the creditor. The surety can also claim indemnity for any special damages which he has suffered while discharging his duties. The surety can claim even if he has paid a time-barred debt, as it is a rightful payment, though there are contrary views on this issue. Against the creditor, following are the rights of sureties against the creditor. The surety is entitled for all the securities which the debtor has provided to creditor, whether surety is aware of it or not, on payment of debt or discharge of payment to the creditor. Where the creditor loses any of the securities by the default or negligence, the liability of the surety reduces proportionately. If the creditor does not hand over the securities to the surety, he can be compelled to do so. Guarantee. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. The contract of guarantee may be expressed or implied and may even be inferred from the course of conduct of the parties concerned. Kinds of guarantee. A guarantee may either be prospective or retrospective guarantee. Retrospective guarantee. A guarantee given for an existing debt or obligation is called the retrospective guarantee. Prospective guarantee. A guarantee given for a future debt or obligation is called the prospective guarantee. A guarantee may be classified either as a specific guarantee or a continuing guarantee. Specific guarantee. When a guarantee extends to a single transaction or debt, it is called the specific guarantee. The specific guarantee is also known as a simple guarantee. Continuing guarantees. When a guarantee extends to a series of transactions, it is called the continuing guarantee. The continuing guarantee does not come to an end on the performance of a single transaction or the discharge of debt, but it will be enforceable for the subsequent transactions also. At the time of giving a continuing guarantee, the surety can either fix the amount of time. Essential elements of contract of guarantee. The essential elements of the contract of guarantee are discussed as under. Concurrence. A contract of guarantee requires the concurrence of all the three parties to it, viz. the principal debtor, the creditor and the surety. Primary liability in some person. There must be a primary liability in some person other than the surety. The word liability as used in the definition of guarantee means a liability which is enforceable at law. If that liability does not exist, there cannot be a contract of guarantee. But a guarantee given for the debt of a minor is an exception to this rule. Essentials of a valid contract. A contract of guarantee must have all the essential elements of a valid contract like free consent, capacity of parties, lawful object and consideration. But the following 2 points should be noted. All the parties must be capable of entering into a valid contract, though the principal debtor may be a person suffering from the incapacity to contract. In such a case, the surety is regarded as the principal debtor and is liable to pay personally, even though the principal debtor, example a minor, is not liable to pay. A consideration received by the principal debtor is sufficient for the surety, and it is not necessary that it must necessarily result in some benefit to the surety himself. It is sufficient if something is done or some promise is made for the benefit of the principal debtor. Writing not necessary. A guarantee may be either oral or written. It may be expressed or implied. The implied guarantee may be inferred from the course of conduct of the parties concerned. Kinds of guarantee. A guarantee may either be prospective or retrospective guarantee. Retrospective guarantee. A guarantee given for an existing debt or obligation is called the retrospective guarantee. Prospective guarantee. A guarantee given for a future debt or obligation is called the prospective guarantee. A guarantee may be classified either as a specific guarantee or a continuing guarantee. Specific guarantee. When a guarantee extends to a single transaction or debt, it is called the specific guarantee. The specific guarantee is also known as a simple guarantee. Continuing guarantees. When a guarantee extends to a series of transactions, it is called the continuing guarantee. The continuing guarantee does not come to an end on the performance of a single transaction or the discharge of debt, but it will be enforceable for the subsequent transactions also. At the time of giving a continuing guarantee, the surety can either fix the amount of time. Revocation of continuing guarantee. On the revocation of a continuing guarantee, the surety's liability comes to an end for the future transactions. However, the surety is liable for previous transactions. A continuing guarantee can be cancelled in the following manner. Notice, the surety may cancel the continuing guarantee for further transaction at any time. Death of surety. A continuing guarantee is cancelled on the death of the surety. In such case, no notice is required to be given to the creditor. However, the contract may provide contrary to the above rule. On the death of the surety, the guarantee is cancelled but for future transaction. Liability is secondary and conditional. The liability of the principal debtor is primary. However, the surety's liability is secondary and conditional. The surety is liable to the creditor only when a default is made by the principal debtor. The creditor can sue the surety without suing the principal debtor. Liability is coextensive with liability of principal debtor. The liability of the surety is coextensive with that of the principal debtor. It means the surety is liable for all the debts payable by the principal debtor to the creditor. Accordingly, the interest, damages, cost, etc., which may be recovered from the principal debtor may also be recovered from the surety. However, the contract of guarantee may provide otherwise, that is, the surety has a right to limit his liability. Surety's liability may be limited. Generally, the liability of the surety is the same as that of the principal debtor. However, the surety may limit his liability by the express provision in the contract of guarantee. Thus, the contract of guarantee may provide that the surety shall not be liable beyond a fixed amount. Discharge of surety and lien. Any variance made without the surety's consent in the terms of the contract between the principal debtor and the creditor discharges the surety as to the transactions subsequent to the variance. A lien means the right to retain the possession of goods till the bailee is paid for his charges for services or any other amount. The lien of goods can be either a general lien or a particular lien. General lien. A certain bailee entitles to retain any goods for any amount due. It is known as a general lien. Particular lien, where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labour or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. Difference between general lien and particular lien. A particular lien is exercisable only on such goods in respect of which charges are due. A general lien is a right to detain or retain any goods of the bailer for the general balance of account outstanding. A particular lien is automatic. A general lien is not automatic but is recognized through an agreement. It is exercised by the bailee only by name. Particular lien comes into play only when there is some labour or skill involved. A general lien can be exercised against the goods even without involvement of labour or skill. Duty to return increase. If the goods which are bailed due to any circumstances get an accretion, the goods should be returned back along with such addition. If some profit arises from the goods, the bailee is bound to return the profit of the bailer. This is, however, subject to any contract to the contrary. Duties of a bailee. Duties of the bailee in the bailment are grouped as under. Duty of care. The bailee should take reasonable care of the goods which are in his possession. The degree of care required by the bailee is similar to that of a man of ordinary prudence would take of his own goods under similar circumstances. Compensation for unauthorized. The bailee should not use the goods for an unauthorized purpose. He can use the goods as per the terms of the bailment. if the bailee makes any unauthorized use of goods, he shall be liable for any loss or destruction of the goods, even if he was not negligent. Duty not to mix. The bailee should not mix the bailor's goods with his own goods. If the bailee mixes his own goods with the bailor's goods with the bailor's consent, the bailor and the bailee shall have an interest in proportion to their respective shares in the mixture thus produced. When the bailee mixes the bailor's goods with his own without a consent and the goods are separable, the bailee is required to pay the cost of separation. But if it cannot be separated, the bailor entitled to be compensated. Duty to return goods. On achievement of the object or completion of the purpose or expiry of contract period, the bailee should return the goods to the bailor. The bailee should return or deliver the goods without waiting for the demand from the bailor. In case if the bailee fails to return the goods to the bailor, the goods will be at his risk. Duty not to set up adverse title. The bailee should not use the goods in such a way that it impairs the right of the bailor. The bailee as such can apply the goods only for the purpose of bailment, and thus he cannot create the adverse title. Duties of a bailor. Following are the duties of a bailor. Duty to disclose fault. It is the duty of the bailor to disclose the known defects in the goods. The bailor should compensate the bailee for such a loss if the bailor fails to disclose such defects, and as a result, if the bailee suffers from any loss. Duty to bear extraordinary expenses. The bailor is liable to reimburse to the bailee all the necessary and extraordinary expenses incurred by the bailee in case of a gratuitous bailment. But in case of non-gratuitous bailment, the bailor is liable to reimburse the extraordinary expenses incurred by the bailee. Duty to indemnify the bailee for any loss. If the bailor does not have any title to deliver the goods on bailment, he would be liable to indemnity to the bailee for any loss which the bailee has paid to the original. Right to claim securities. The surety is entitled for all the securities which the debtor has provided to creditor, whether surety is aware of it or not, on payment of debt or discharge of payment to the creditor. Where the creditor loses any of the securities by the default or negligence, the liability of the surety reduces proportionately. If the creditor does not hand over the securities to the surety, he can be compelled to do so. Right of set-off. Set-off means the deductions from the amount of loan. The surety has a right of set-off against the principal debtor exactly as a creditor would have. Against co-sureties. When two or more persons give a guarantee for the same debt, they are termed as co-sureties. All the co-sureties are equally liable to the creditor in the absence of any contrary contract. The rights of the co-sureties are discussed as under. Right to contribution. When one co-surety pays the debt or discharges the entire obligation, he can recover equal contribution from the other co-surety. This rule is applicable whether the sureties are liable jointly or severally, and whether their liability is under the same contract or a different contract. Right to share the benefit of securities. If the one co-surety receives any security from the principal debtor at the time of guarantee or from the creditor on discharge of debt or obligation of the principal debtor, other co-sureties are entitled to share the benefit of the securities. Difference between contract of indemnity and contract of guarantee. Contract of indemnity. There are two parties to the contract, viz. The indemnifier, promissory, and the indemnified, promise. Liability of the indemnifier to the indemnified is primary and independent. There is only one contract in case of the contract of indemnity, that is, between the indemnifier and the indemnified. It is not necessary for the indemnifier to act at the request of the indemnified. The liability of the indemnifier arises only on the happening of a contingency. Contract of guarantee. There are three parties to the contract, viz. the creditor, the principal debtor, and the surety. Liability of the surety to the creditor is collateral or secondary, the primary liability being that of the principal debtor. In a contract of guarantee, there are three contracts between the principal debtor and the creditor, between the creditor and the surety, and between the surety and the principal debtor. It is necessary that the surety should give the guarantee at the request of the debtor. There is usually an existing debt or duty, the performance of which is guaranteed by the surety. Finder of goods. The person who finds the goods belonging to some other person and takes them in his possession is known as the finder of goods. Following are the duties of the finder of goods. The finder of goods must take reasonable care of goods. The finder of goods must return the goods to the owner when found. The finder of goods must not use goods for his own purpose. The finder of goods must not mix goods with his goods. The finder of goods must return any increase in goods along with goods. The finder of goods must take reasonable effort to find owner. Pledge. A pledge is a special kind of bailment. Here the goods are delivered as a security for the payment of debt or for the performance of a promise. The person who delivers the goods is known as the pledger or pawnee, and the person who receives the goods is known as the pledgee or pawnee. Rights of pawnee. Following are the rights of pawnee with reference to the goods pledged. Right of retainer. The pawnee can retain the goods pledged with him until he is paid. Money advanced by him, necessary expenses, interest paid on debt, but the pawnee has no right to retain the goods even for subsequent advance. Extraordinary expenses. The pawnee has a right to retain the extraordinary expenses related to the goods from the pawner for the preservation of the goods pledged with him. When pawner defaults. If the pawner makes a default, the pawnee has a right to sell the goods after giving notice of his intention to sell goods. Even if the title of the pawner is defective, the pawnee gets valid title. If sale proceeds of goods by the pawnee are less than the amount of debt, the pawnee can recover such deficit from the pawner. To sell goods. The pawnee can sell the goods if the pawner makes a default after giving reasonable notice. The contract may exclude this right. If the sale is made by the pawnee without notice is void. Pledges by non-owner. An owner of goods can create a pledge. However, this is subject to certain exceptions as under. Mercantile agent. A mercantile agent means an agent who has the authority to sell the goods in ordinary course of business. At the time of creation of pledge, the pawnee has no notice of the fact that the mercantile agent had no authority to pledge the goods. Possession under voidable contract. The person possessing the goods under a voidable contract can make a valid pledge on the satisfaction of following conditions. The voidable contract has not been declared as void. The pawnee must act in good faith. He should not have any notice of pawner's defective title. Person with limited interest. When a person pledges the goods in which he has only limited interest, the pledge is valid only to the extent of such limited interest. Seller in possession after sale. When the seller continues to be in possession of goods even after sale, he can make a valid pledge of goods. The pledge is valid only if the pawnee acts in good faith and had no notice of previous sale. Summary. Now in the end, let us summarize what we have learnt in this lecture. A contract of guarantee must have all the essential elements of a valid contract. A lien means the right to retain the possession of goods till the bailee is paid for his charges for services or any other amount. The person who delivers the goods is known as the baler, and the person who receives the goods is known as the bailee, and the transaction is known as bailment. The indemnity holder is entitled to recover from the indemnifier. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor.